In the intricate world of inheritance and family dynamics, contesting a will may seem like a cold legal process, but in reality it's a complex interplay of emotions, relationships, and the pursuit of justice. As an experienced lawyer, I've seen firsthand how the decision to challenge a will can be driven by a profound desire to protect a loved one's legacy and uphold their true intentions. In order to contest a will in Australia, the person challenging a will must have legal standing. This means that they must be an eligible person, such as a spouse, a child, or financial dependent of the deceased, as defined by the relevant state or territory laws. There are several grounds on which a will can be contested, including a lack of testamentary capacity. The claimant may argue that the deceased person did not have the mental capacity to make a valid will. Undue influence. The claimant may argue that the deceased person was coerced or unduly influenced when making the will. Fraud or forgery. The claimant may argue that the will was fraudulently created or forged. And finally, inadequate provision. Here the claimant argues that the deceased did not make adequate provisions for them in their will, given their relationship to the deceased and their financial circumstances. If a person believes that any one of these circumstances have occurred, which resulted them in either being left out of a will or receiving less than what they were either promised or expected, they would be able to challenge the will and make what is called a family provisions claim. The most common reason a person challenges a will is because they have not received what they either expected or was promised. For example, you could have one child who lived with a parent and looked after all aspects of that parent's life before they passed away, only to find that another sibling had taken the parent to see a solicitor and changed their will without their knowledge. In New South Wales, there are specific rules that determine who has legal standing to contest a will. These rules are set out in the Succession Act 2006 and include the following categories of eligible persons. A spouse or de facto partner of the deceased at the time of the death has legal standing to contest a will. Children. A child of the deceased person, including adopted and stepchildren, may be eligible to contest the will if they were wholly or partly dependent on the deceased at the time, or if there are insufficient provisions in the will for their proper maintenance, education, or advancement in life. Former spouses or partners. In some circumstances, a former spouse or de facto partner of the deceased person may have legal standing to contest a will. Other dependents. Other dependents of the deceased person, including grandchildren or other relatives who were dependent on the deceased for financial support, may also be eligible to contest a will. It is important to note that even if a person has legal standing to contest a will, it does not guarantee that their claim will be successful. The outcome of a claim would depend on a number of factors, including the specific circumstances of the case, what the will said about the distribution of assets, the evidence that is presented to the court, and the level of dependency. The steps to contesting a will. Number 1. Seek legal advice. Seek advice from a lawyer who's experienced in estate planning. The lawyer can review the relevant facts, the laws, and the specific circumstances to determine if you have legal standing to contest a will. Step 2. Make a claim. If a person has legal standing to contest a will, the next step is to make a claim. This involves lodging a formal claim with the Supreme Court of New South Wales, which oversees will disputes. The claim must be made within 12 months of the will maker's passing. Step 3. Mediation. Before the case goes to court, the parties may be required to attend mediation to attempt to resolve the dispute without the need for a formal hearing. Mediation is a process where an independent mediator assists the parties in trying to negotiate a settlement. Step 4. Court proceedings. If mediation fails and is unsuccessful, the case will proceed to a formal hearing in court. The court will consider the evidence presented by both sides, including witnesses, testimony, as well as documentary evidence. Step 5. The decision. After considering all of the evidence, the court will make a decision on the matter. The court may order that the will be changed to provide for the person making the claim, or may reject the claim and uphold the original will. The first step would be to file a caveat. This effectively, in plain English, stops the assets of the state from being distributed while you're contesting the will. The second step is to file a summons. The person contesting the will, the plaintiff, must file a summons with the Supreme Court of New South Wales within the 12-month limitation period. The summons set out the grounds for challenging the will. The summons must be served on all parties with an interest in the estate, including the executor of the will, most importantly, beneficiaries, as well as other potential claimants. Once the summons has been served, the defendants, usually the executor and beneficiaries, have an opportunity to file a defence and a response. This sets out their position to your claim and the grounds on which they will contest it. After this is done, the matter gets brought back to court for what is called a directions hearing. The judge or registrar to determine the next steps in the process, including discovery, exchange of evidence, as well as an initial trial date. We talked about mediation before. In most cases, the court may order the parties to mediate to try to resolve the dispute without going to court first. However, if the mediation fails, the matter will proceed to trial and the parties will need to present the evidence to court, including witness statements, financial records, medical reports, and the judge will hear arguments from both sides and make a decision on the case. It is important to note that each case is different and the court process can be varied depending on the specific circumstances of a case. Some cases may be resolved through negotiation or mediation before trial, while others may require a more complex and lengthy trial process. If a will is successfully contested in New South Wales, there are several potential outcomes that can occur. The first is the will may be declared invalid, and if the court determines that the will is not valid, it will be set aside and the deceased's assets will be distributed according to the rules of intestacy. This means that assets will be distributed in the following priority: to the deceased spouse, then to the children, then to the parents, then to the brothers and sisters of the deceased, then to the grandparents, etc. The court may also vary the terms of the will if they determine that the deceased did not make adequate provision for certain family members or dependents. In this case, the court will consider that additional assets may be distributed to these individuals. Another outcome will be that the will may be upheld with additional provisions. In some cases, the court may uphold the will but order that additional provisions be made for certain family members or dependents. For example, the court may order that a specific sum of money be provided to a dependent child or spouse because they weren't adequately provided for in the will. In general, a family provisions case can take anywhere from 1 to 2 years to resolve, depending on the complexity of the case. If the case is straightforward and there are no significant disputes, it may be resolved relatively quickly. However, if the case is complex and there are many parties involved or multiple legal issues to be addressed, the case may take longer to resolve. As the court process can take a long time, if the parties are able to reach a settlement outside of court, the case may be resolved more quickly, and settlement negotiations are always recommended. However, if settlement negotiations are contentious or break down, the case will need to then proceed to trial, and this can add time to the process. The most important part about contesting a will is to seek the right advice. Contesting a will is a complex and emotionally charged process. It is important to work with an experienced estate lawyer to help you evaluate the strength of the case as well as develop a strategy for contesting the will. You also have to act quickly. In New South Wales, there are strict time frames for contesting a will. It is important to act quickly and seek legal advice as soon as possible to ensure you don't miss any deadlines. In order to contest a will, you will need to provide evidence to support your claim. Make sure you gather all of the relevant evidence as soon as possible and give it to your lawyer so we can start assessing your case. You should also consider mediation. Mediation can be a useful way to resolve disputes without a need for a lengthy and costly court battle. Your lawyer can advise you whether mediation is a viable option. We always tell our clients, be prepared to negotiate. Contesting a will involves negotiation and compromise. It is also important to manage your expectations and be realistic about the possible outcomes.